kitchen, Stephanie will go to the same. Welcome to the state mock trial competition. My name is Nathan. I'm on the mock trial leadership team. I'll be your host for this evening. We are still waiting on our bailiff, so you can continue just to hang tight for right now. If you are missing anybody, please let me know. Until then, appreciate your pay.
Thank you. Do any of the jurors know which ballot box or which ballot this is, A, B, or C? It's okay if you don't. I just thought I'd ask.
I have ballot C. I have
Oh, I
ballot
guess we have a different one possibly. Okay. All right. That answers my question. Thank you. It's always hard to find a bailiff on a Friday night. Mr. Westland, are you our bailiff today?
Sorry, Your Honor, I didn't hear you.
Said Mr. Westland, are you the bailiff or Wantland? Are you
Yeah,
the
no,
bailiff?
I'm one of the scorers today.
Okay, sorry.
No, it's all right.
I think the bailiff is the actual timekeeper, if I'm not mistaken. So
Yes, Your Honor, that's correct.
I need one of those.
Yeah, we sure do.
Miss Tricia, are you our bailiff today?
I am.
We are glad to see you.
Thank you. We had to get set up, but I'm ready when you are.
You're fine. I wanted to say, do you need an extra minute or anything to get ready?
I'm ready.
Okay. Well then, Ms. Tricia, if you would please open court for us.
Okay. This honorable court is now in session with Circuit Court Judge Sammons presiding. Before this court is case number CV 4370469-19, Saylor versus Jennings. Please come to order.
Thank you. And before we start this hearing, are there any preliminary matters that need to be taken up? On behalf of the plaintiff, we'll ask first.
Yes, Your Honor, the plaintiff does have a couple preliminary matters. First, under Rule 17, we ask that bench conferences be held out in the open for educational purposes. And we also ask that pursuant to Rule 33, we'd like to enter the agreed upon stipulations and evidence.
All right. Is there any objection from the other side?
No objections, Your Honor.
All right. The stipulations will be admitted and also the rules will be followed. Thank you. Any preliminary matters from the defense?
Yes, Your Honor, just a few brief preliminary matters. First, may we enter our appearances for the record?
Sure. Introduce yourselves.
Good evening, Your Honor. My name is Ashwin Jain, and today I'm joined by my co-counsel, Mr. Reed Smith.
Good evening, Your Honor.
Good evening.
And Mr. Tania Roy.
Good evening, Your Honor.
I'm Mr. Roy.
Together, we represent the defendant, Mr. Drew Jennings, in today's case. Now, we are also joined by a paralegal from our office, Mr. Jude Bueno. Now, you won't see or hear from Mr. Bueno throughout today's proceedings, but he'll be keeping time, running the technology, and doing his level best to keep us on track throughout today's proceedings. Secondly, Your Honor, I would like to, opposing counsel entered in the agreed upon stipulations. I would like to turn the court's attention to stipulation 12. Mr. Bueno, if we could get stipulation 12 on the screen, please. Your Honor, as both parties have already stipulated to, this trial has been bifurcated, which means that any testimony about the extent of damages is inadmissible in today's proceedings.
So noted.
And with that, Your Honor, the defense is ready to proceed.
Thank you. All right, I'll ask the bailiff, Ms. Tricia, if you will, please swear in the witnesses. If anyone is intending to testify in this matter, at this time, please turn on your video and your audio and raise your right hands to be sworn. Thank you, bailiff. Go ahead, Ms. Tricia, and administer the oath.
Okay. Do you solemnly swear or affirm that the testimony that you give today will be in accordance with the rules of the mock trial competition?
I do.
I do.
Oh.
Thank you. Mr. McQueen, or excuse me, Mr. Schultz, please call your first witness.
Yes, Your Honor. At this time, the plaintiff calls Bryson Saylor to the stand.
This witness has been sworn. Go ahead when you're ready.
Your Honor, may we do opening statements before we move on to direct examinations?
Of course we can. I'm sorry. It's late on a Friday night, and I totally skipped that. Thank you for bringing it to my attention, Mr. Smith. My
No
mistake.
problem.
But that is why I was thinking of Mr. McQueen. Mr. McQueen, are there any opening statements the plaintiff would like to give before we?
Yes, Your Honor.
Go ahead.
May it please the court, counsel, and members of the jury. My name is Ethan McQueen, and today co-counsel and I will be representing the plaintiff, Bryson Saylor. Let me introduce you to a man who was treated well by his community. Raised with them since birth, he decided he needed to give back. He gave back to his community through a passion he had. This passion was chicken sandwiches. He served chicken sandwiches for years and years and years. He loved his community, and this community loved him back. However, after serving the community of poultry for decades, he had a new competitor in town. With this newfound excitement in his community, he temporarily lost part of his business. Angry with himself, he wanted to know what he could do better. He then took a fateful trip on September 5th to his competitor's restaurant, Eat More Chicken. He was on a mission to help improve his product. Now, on the other hand, we have Drew Jennings, the owner of Eat More Chicken. While she was not new to working in chicken restaurants, she was new to running a chicken restaurant. These record-breaking sales and massive protests overwhelmed her at a fateful meeting point between Bryson Saylor and Drew Jennings. Drew Jennings decided to act irrationally on September 5th like she had her entire life. While Bryson Saylor was on a mission to help improve his community, Drew Jennings was on a mission to stop her competition through any means necessary. Drew Jennings decided to accomplish this mission and put a screw in Bryson Saylor's sandwich with insidious intent. Today, ladies and gentlemen, with these characters, we will show you the timeline on how and why Drew Jennings placed a screw in Bryson Saylor's sandwich. First, we will introduce Bryson Saylor to talk about the fateful day of his encounter with Drew Jennings. He will help explain his passion of chicken and the help that he wanted to provide to his community. He will then talk about the awful pain he experienced at the hands of Drew Jennings and how he still suffers for it, even in this very courtroom today. Next, we will introduce Austin Biltmore. Biltmore was a protester that day working outside the restaurant to spread his message. He will help explain how Drew Jennings decided to forcefully shove a cashier out of the way exactly when Mr. Saylor decided to place his order. He will explain how Drew Jennings placed a toolbox next to Bryson Saylor's food at the counter with the exact same nail that Saylor swallowed. Biltmore will then explain how Drew Jennings opened up Bryson Saylor's order while no one was around and decided to physically rearrange his sandwich. Biltmore will help explain the intent that was there. Finally, we will introduce Dr. Cameron Cares. Cares will explain the extreme, agonizing pain that Mr. Saylor suffered at the hands of Drew Jennings and the horrific procedures and dozens of doctor visits he needed to overcome the pain inflicted by Jennings that day. Cares will explain how insidious the pain inflicted really was. Throughout this timeline, opposing counsel will frame multiple incidents as just tiny little happenstances and coincidences. Now, was it a coincidence that Drew Jennings pushed a cashier out of the way to take Bryson Saylor's order and only Bryson Saylor's order? Was it a second coincidence that Drew Jennings brought a toolbox that contained the exact same screw that Bryson Saylor swallowed when handling Bryson Saylor's food? Was it a third coincidence that Drew Jennings decided to open the box containing the sandwich that Bryson Saylor was about to eat and then rearrange the sandwich after having direct access to a screw? Was it a fourth coincidence that the same sandwich in which Drew Jennings and only Drew Jennings had direct contact with was the same sandwich which contained a screw placed to hurt Bryson Saylor? Was it a fifth coincidence that Drew Jennings sent Bryson Saylor a message on Twitter stating, "I'm going to enjoy watching your chicken kingdom crumble," a few hours before Bryson Saylor swallowed a screw? We will ask you to realize that these are not coincidences like opposing counsel will try to frame them, but instead insidious intent from Drew Jennings to harm Bryson Saylor. Today, ladies and gentlemen, we only need to prove that there was intention from Jennings to harm Bryson Saylor, not that any harm occurred. And remember, the burden we have to prove is that it was only more likely than not that Drew Jennings harmed Bryson Saylor. However, we believe that we will present an overwhelming amount of evidence to show the harm that Bryson Saylor faced. We hope that you, the jury, can help protect Mr. Saylor by providing a straightforward rebuttal to Drew Jennings' plan so that Mr. Saylor can return to his community. Thank you so much.
Thank you, Mr. McQueen. Mr. Jane, on behalf of the defense.
Yes, Your Honor. May it please the court, opposing counsel, and members of the jury. Killing two birds with one stone. It's a saying I'm sure most of you are familiar with. It means to accomplish two goals with one action. Birds and one stone. And that's precisely what this case is really about. It's about someone who attempted to harm two businesses by casting just one stone. Or in this case, one screw. You see, the picture Mr. McQueen just painted for you is that of a victim and a culprit. He wants you to believe that Bryson Saylor, and the owner of a local chicken restaurant, is a victim, while Drew Jennings, the owner of a competing local chicken restaurant, is a culprit, supposedly placing screws in his own restaurant's food. Now, members of the jury, I'll have to admit that Mr. McQueen, well, he's got it half right. Bryson Saylor is undoubtedly a victim, most likely of an intentional battery. But what the evidence in today's trial will show you is that Drew Jennings is no culprit. And when someone placed a screw on Bryson Saylor's sandwich on September 5th of 2019, both Drew Jennings's personal business and Bryson Saylor's personal health were under attack. Two birds attacked with just one screw. Now I know you're asking some obvious questions. Does someone have motive to harm both Bryson Saylor and Drew Jennings? And if so, was such a person present at the Eat More Chicken restaurant on September 5th of 2019? And if so, did that person have access to the chicken sandwich just before it was served to Bryson Saylor? Members of the jury, the evidence in today's trial will show you that the answer to every one of those questions is yes. You see, a group of animal rights activists determined to stop the meat industry had targeted and harassed Bryson Saylor for years, so badly so that they'd even been arrested by the police. Now, the same group of protesters was present at my client's restaurant on September 5th, protesting the sale of meat. But when their long-term target, Bryson Saylor, arrived in the parking lot, protesters suddenly were presented with two targets in one location. Two birds they could attack with one screw. And that's exactly what they did. An eyewitness from the parking lot will testify to seeing one of these protesters follow Bryson Saylor inside the restaurant. And moments later, this same protester was seen alone with my client's food, or with Bryson Saylor's food, just before it was served to him. And Drew Jennings will even testify that he had briefly left the food unattended in the dining room while he went to the back to retrieve some napkins. When he returned, he noticed the top bun of the chicken sandwich had been moved slightly. Unaware that his restaurant and Bryson Saylor's personal health were under attack, Drew Jennings simply straightened the bun in the chicken sandwich and served Bryson Saylor his food. Well, unfortunately, the rest is history. So given that logical explanation, why is the plaintiff suing Drew Jennings instead of the chicken protester seen alone with his food? Members of the jury, the answer is quite simple. Bryson Saylor is attempting to save his own business. Miss Saylor's own accountant will testify to a 25% decrease in sales just after Mr. Jennings opened up his business. Was it a coincidence that Miss Saylor incurred a decrease in sales just after Mr. Jennings opened up his business? Mr. Smith Saylor's own accountant will even testify that he overheard Miss Saylor admit that he was going to put a stop to it no matter what it took. It was after that phone conversation took place that this lawsuit was filed. Now the plaintiff's attorneys are here asking you to believe that my client sabotaged his own restaurant. Luckily, the law doesn't merely allow the plaintiff to accuse Mr. Jennings. Rather, they have what's called the burden of proof. They have to prove every element of their intentional battery claim by a preponderance of the evidence, which they will fail to do. There will be no evidence that Mr. Jennings had any motive to harm Bryson Saylor. There will be no evidence that Mr. Jennings intended to sabotage his own business, and there will certainly be no evidence that Mr. Jennings put a screw in Bryson Saylor's sandwich. And that's why at the end of today's trial, my co-counsel, Tania Roy, we'll ask that you find the protesters attempted to attack 2 birds with 1 screw. We ask you return verdict in favor of Drew Jennings. Thank you.
Thank you, Mr. Jane. Now, Mr. Schultz, would you like to call your first witness?
Yes, sorry, Your Honor. This time the plaintiff calls Bryson Saylor to the stand.
All right, Mr. Saylor has been sworn.
Please state your name for the record.
My name is Bryson Saylor,
And where are you from, Mr. Saylor?
right here in Poultry, Tennessee.
And what's your current occupation?
Well, I'm the owner of Sailorman's Chicken, like I have been for the past 20 years.
Now, what were you doing on September 5th?
On September 5th, I had a meeting planned with my accountant to go over the financials for the month of August.
And what were these financials?
My accountant informed me that sadly, my sales had gone down 25% compared to the previous August.
And so what did you do after hearing about these financials?
Well, I was devastated. I was extremely disappointed that I'd allowed my business to fail so much so that a new kid on the block could just come in and steal a quarter of my customers.
And who is this new kid on the block?
That'd be Eat More Chicken.
And who operates the Eat More Chicken and Poultry?
Drew Jennings.
And so after your meeting with your accountant, what did you decide to do?
Well, I decided that I wasn't just going to sit around and allow my business to continue to fail. I was going to do whatever I could to make sure that my business improves, whether that be improving its chicken or improving its customer service. I was going to go over to Eat More Chicken and figure out what they were doing better so that I could improve my own business and win back my customers that I love.
And so once you arrived at Eat More Chicken, who took your order?
That'd be Drew Jennings.
And how was Mr. Jennings acting?
Straight from the get-go, it was kind of odd because the person who was supposed to take my order got shoved out of the way by Drew Jennings. And
Objection, Your Honor. Improper character evidence under Rule 404B may be heard further in a constructive bench conference outside the presence of the jury.
Well, you can be heard here at the bench. Yes, that's fine.
Yes, Your Honor.
What's the objection?
Improper character evidence under Rule 404B. Your Honor, the plaintiff just offered evidence that my client allegedly shoved someone. This is a specific instance of conduct that the plaintiff is using to trick the jury into believing that because my client acted violently on this occasion, he's more likely to do so and commit this battery. That is an action in conformity therewith. This propensity chain of reasoning is exactly what Rule 404B disallows, Your Honor.
Mr. Schultz, any response?
Yes, Your Honor, if I may. What Mr. Saylor is describing here and what Ms. Saylor is about to go into is just Mr. Saylor's actual eyewitness account to what happened on September 5th. And as it is that we are here today to discuss what happened on September 5th at Eat More Chicken, I believe it's perfectly relevant and appropriate to go into Mrs. Jennings and Mr. Saylor and how they were both acting.
Overruled.
Thank you, Your Honor. Now, again, Mr. Saylor, I'll ask again, how was Ms. Jennings acting?
well, like I said before, when I actually arrived to the counter, the cashier that was supposed to take my order got pushed out of the way by Drew Jennings. And the entire time that Drew Jennings was taking my order, he seemed a little too eager, a little too happy to take my order. It was odd.
And so after you had your order taken, who brought your food out to you?
That would be Drew Jennings, Mr. Schultz.
And then what happened?
Well, I mean, right after Drew Jennings dropped off the food, everything seemed normal. I took a bite of my chicken sandwich, and that's when I ended up swallowing the screw.
And what happened after you realized you had swallowed something sharp?
Well, at first I thought it was a chicken bone, but as it went down my throat, I knew that it couldn't be a chicken bone. It was too sharp. There was too much pain. I screamed out for help.
Now, did help ever come?
Yes. Thankfully, the manager ran straight over to me and asked me if he wanted me to call an ambulance.
Did you accept this ambulance ride?
No, because I knew that the ambulance was going to take forever to get in and out of that restaurant and get me to the hospital safely. I mean, Eat More Chicken had one of the busiest lunch rushes I've ever seen that day.
And so how did you get to Poultry Community Hospital?
Well, thankfully I could still breathe, so I just drove myself over.
And what happened after you arrived?
Well, I went straight to the ER because I still felt it in me. And I got there, told them I'd swallowed something sharp, and they ran a lot of tests and did a lot of x-rays, and that's when I actually first learned that I'd swallowed a screw.
And what happened next?
They told me that to get the screw out, they were going to have to shove a metal tube down my throat. I mean, the entire time I was freaking out. I thought I might not ever be able to eat chicken again. It was terrible.
Objection, Your Honor. Pursuant to Rule Stipulation 12, this trial's already been bifurcated. The fact that a tube was shoved down his stomach in this Mr. Saylor's testimony to the fear that he felt goes to the nature and amount of these damages and is not relevant to the mere burden of pain that they need to prove as part of their battery claim today.
Mr. Schultz?
Yes, Your Honor. Yes, Stipulation 12, I'll read it, is the nature and amount of damages are not subject of argument in this problem. However, we are not going to be providing this as an argument towards Drew Jennings, or if Miss Jennings did this because if Mr. Jennings, I'm sorry, if Mr. Jennings did this and these are the damages of it. Instead, we're proposing this because as opposing counsel has briefly proposed, we're just establishing that Mr. Saylor would have never done this to himself. And that's why we're bringing up these damages to clarify that Mr. Saylor has no right to do this himself.
All right, I'll overrule the objection.
Thank you, Your Honor.
Mhm.
And Mr. Saylor, you can continue again. What happened during the procedure and after?
Well, like I said, they had to shove a metal tube down my throat in order to get this screw out. And I mean, thankfully the doctors treated me well. And afterwards they said that I avoided any big serious damage, but I still felt it in me, if that makes sense. You know, although the screw came out and I knew that it wasn't inside, I still felt it. And that fear of not being able to eat chicken was still there with me. So although the doctor said that nothing major happened, they said that it was probable that some smaller damages could have happened, that they couldn't pick up on their older machines.
Objection, Your Honor. Hearsay. This is an out-of-court statement made by these doctors to prove the truth of the matter asserted, that there were outdated machines.
Mr. Schultz?
Yes, Your Honor. Under hearsay exception 4, statements of purposes of medical diagnosis and treatment. This is covered, and Mr. Saylor is just briefly recounting as what the doctors told him this day.
May I respond?
Well, I sustain the objection because it was actually a statement made by the doctor, not the patient. Sustain the objection.
And move to strike that testimony from the record, Your Honor.
It'll be strict.
Yes, sir.
Thank you. Now, Mr. Saylor, did you on September 5th intentionally swallow this screw?
No. The entire time that I had that screw in me, there wasn't a fear of, you know, what my business would happen. There was a fear of whether or not I would make it out alive. The entire time that the procedure was happening, I thought, you know, maybe I might not ever be able to eat chicken again. My entire livelihood would be over. I would never risk that, and I would never risk my life just to swallow some screw.
Thank you. No further questions, Your Honor.
Thank you. And Mr. Smith, are you doing the cross?
Yes, Your Honor. May I have a brief moment to rearrange my camera?
Yes.
Thank you, Your Honor. May I proceed, Your Honor?
Sure.
Now, Mr. Saylor, you've been in the restaurant business for over 20 years, correct?
Yes, sir, I have. I've actually been selling chicken sandwiches since I was 7 years old. I used to sell them out the back of my dad's pickup truck when I was at football games. My entire life has basically been around chicken sandwiches.
That's exactly right. So then you would agree with me that public reputation is important in the restaurant business, right, Mr. Saylor?
Yes, sir, I would, Mr. Smith.
Good food, good service, clean facilities. Those are all things that impact a restaurant's reputation, right?
Yes, sir. I mean, that's the core values of a business.
That's exactly right. And if a restaurant has a good reputation, You'd agree that's good for business, right?
Yes, sir.
Conversely, if a restaurant has a bad reputation, that's likely bad for business, right?
Yes, sir.
And you certainly would agree with me that if a restaurant were to serve a customer food containing a foreign object, that's the type of thing that would damage a restaurant's reputation, right?
Yes, sir. And that's why it would never happen at Sailorman's.
And as you said, if it damages the reputation, it would damage that restaurant's business and be bad for business, correct?
It would be.
Mr. Saylor, your claim to this jury is that my client did just that. You claim he intentionally served you a metal screw in your chicken sandwich and thereby intentionally harmed his own business? That's what you're claiming?
Well, yes, because that's what happened. I mean, right after he dropped off the chicken sandwich, I ended up swallowing a screw. I mean, there's no other way to explain that. I wouldn't do it to myself. I'd be risking my own business in that same process.
Well, I'm not accusing you of doing it yourself, Mr. Saylor. We'll talk about other explanations later. But the truth is you didn't see my client put a screw in your sandwich. Did you, Mr. Saylor?
No, sir, I didn't.
You have no witnesses that can come here and say they saw my client put a screw in your sandwich?
Well, I don't know of any other witnesses like
Now,
testimony.
I read the complaint you filed in this case and that you said my client acted with, quote, malicious intent, unquote. But in reality, he was quite polite towards you when y'all interacted at the restaurant, right?
I would argue that it wasn't politeness. It was sort of like a face that was too happy, too eager to serve me. And the fact that he had to shove a cashier out of the way to, take my order, that would never happen in my restaurant.
So you're not faulting my client for being too hostile or angry towards you, but rather for being too friendly. Am I understanding that correctly?
The entire interaction, it was odd.
So that's a yes to my question. You're faulting my client for being too friendly?
Yes.
Well, the truth is, Mr. Saylor, you didn't have any disagreement or conflict with Mr. Jennings at the Eat More Chicken restaurant that day, did you?
No, I didn't.
Let's talk about who you did have both disagreement and conflict with. There was a group of protesters there protesting the sale of chicken, right?
Yes, there was. They were right outside of the restaurant, and they were dressed in animal costumes, and they've gone to Sailorman's multiple times.
And you actually recognized this group of protesters because they protested at your restaurant, Sailorman's, in the past, correct?
Yes, Mr. Smith.
Objection, Your Honor. Relevance.
May I be heard, Your Honor?
Yes, did you want to explain your objection, Mr. Schultz?
Yes, Your Honor. I don't see. I'm sorry. I would like to say I feel like I am a bit behind in case my objections come out of nowhere. But yes, this is how Mr. Saylor sees these protesters, or why these protesters are even at Eat More Chicken, just is completely irrelevant to why we're here today, which is Mr. Saylor swallowing a screw.
All right.
May I respond, Your Honor?
Sure.
Your Honor, it's the defense's contention today that these protesters actually had the opportunity, motive, and means to put a screw in the plaintiff's chicken sandwich. And pursuant to Rule Stipulation 12, we're allowed to explore these possibilities of opportunity, motive, and intent that these protesters would have had.
I'm going to overrule the objection.
Now, Mr. Saylor, I was asking if these protesters had protested at your restaurant, Sailorman's, in the past.
Yes, they have.
And when they protested at your restaurant, you actually called the police on them because they were bad for your business, right?
Yes, sir. I mean, there were several customer complaints about being uncomfortable about the protesters being there. And I value my customers highly, They're the ones that keep my business in shape. They're the ones that keep me open. So if something's making them uncomfortable, I wanted to get it out of my restaurant.
That's exactly right. In fact, your relationship with this group of protesters became so bad, you actually had their leader arrested for harassment, didn't you?
Well, yeah.
And on September 5th, these protesters were protesting at my client's restaurant, correct?
Yes, they were outside of Eat More Chicken.
Now, you already told this jury on direct examination that the screw being in your sandwich was painful to you and caused you harm, correct?
Yes, sir. I mean, I wouldn't wish that kind of pain on anybody. It was terrible.
I'm very sorry to hear that, Mr. Saylor. You also said that a restaurant serving a customer food containing a foreign object is bad for business. You told me that earlier?
Yes, and it would never happen in Edmonds.
So, Mr. Saylor, here's my question. If one of those protesters wanted to harm both my client's restaurant business and your personal health, then the single act of putting a screw in your sandwich would accomplish both of those goals, wouldn't it, Mr. Saylor?
Objection, Your Honor. This is outside the scope of this witness's statement.
I'll allow the question.
I'll ask that again, Mr. Saylor. You would agree with me that if one of these protesters wanted to accomplish both, to harm both your personal health and my client's restaurant business, that would mean that the single act of putting a screw in your sandwich would accomplish both of those goals, wouldn't it, Mr. Saylor?
No, sir. I don't even know why they would want to damage my health in the first place. I mean, we've had our rough run-ins, but I don't see it justifying them putting a screw in my chicken sandwich.
But you would agree that if they did put a screw in your sandwich, then it would harm your health, correct?
I'm kind of confused by the question. Are you talking about my health or the business?
Your health. You told us that the appearance of a restaurant serving a customer a screw in its sandwich is bad for you, correct?
Yes.
And you told us that a screw in your sandwich is bad for business, right?
Yes.
So the combination of those two things could both be accomplished by the single act of a screw in your sandwich, right?
Well, I don't understand why they would put a screw in my chicken sandwich. I mean, yeah, we've had our troubled past, but I would never put a screw in their chicken sandwich or anything like that.
I'm not saying you would, Mr. Saylor. I have one more thing I want to ask you about. You told this jury earlier that you didn't see my client put a screw in your sandwich. Got another important question about that. Did you or did you not see one of those chicken protesters alone with your chicken sandwich right before it was served to you?
No, sir.
Mr. Saylor, if that were to be shown in trial today, if one of those protesters was alone with your chicken sandwich right before it was served to you, that'd be something you didn't know when you filed this lawsuit against my client, would it, Mr. Saylor?
Well, I guess not. I guess I didn't know that. But to be honest, if these protesters do value the lives of animals as much as they say they do, then I'd have to guess that they value human lives just as much. And I couldn't see them risking my life or anybody else's lives for that matter to put a screw in my chicken sandwich and possibly cause me harm.
All right. Well, I appreciate your testimony today, Mr. Saylor, and I'm sorry for all you've gone through. No further questions, Your Honor.
Thank you. Mr. Schultz, any brief redirect?
Yes, briefly, Your Honor. Now, Mr. Saylor, opposing counsel said that you called the police on protesters due to them being bad for your business. So I need to ask you, would you ever put your business in harm's way?
No, sir, I wouldn't. I mean, my business is my entire life.
And would you ever put yourself in harm's way?
No, I wouldn't.
Thank you, Your Honor. No further questions.
Thank you. Mr. Smith, any brief recross?
No recross, Your Honor.
All right, thank you. You may step down. Plaintiff, please call your next witness.
Good evening, Your Honor. My name is Trent White, and we are calling Dr. Cameron Cares to the stand.
Dr. Cares has been sworn. Thank you. Go ahead when you're ready.
Please state your name for the court.
Dr. Cameron Cares.
And what is your occupation, Dr. Cares?
I'm a gastroenterologist.
And where do you work?
Poultry Community Hospital.
How long have you worked at Poultry Community Hospital?
15 years.
Your Honor, I would now like to share with the bench what has been marked as Exhibit A. Let the record reflect the opposing counsel has been shown the copy.
All right, before you publish it to the court, I'll ask the other side, is there any objection to the admissibility of this document?
No objections, Your Honor.
All right, then go ahead and publish it.
Thank you, Your Honor.
Mhm.
Can everyone see that?
Yes.
Wonderful. Now, Your Honor, I would now like to move Exhibit A into evidence. Its authenticity has been stipulated.
There was no objection, so it will be admitted.
Wonderful. Thank you, Your Honor.
Your Honor,
Now, Dr. Cares, what education have you received in connection to?
I apologize, Mr. White. I think there is an objection. Mr. Jane?
yes, Your Honor. I object to lack of foundation. The witness has not said that this is, in fact, his CV or has not told the court that it is an accurate copy of it.
Yes, Your Honor, I can do that now.
Well, what's your response to that? You want
I
to
can
do that?
right now.
The reason I asked you about the publication is because really you shouldn't publish it to the court until it's deemed admissible, but that's all right. And I apologize, but in the future, and if anyone's trying to admit an exhibit, I'll ask you that preliminary question at that time. And then if any side has an objection, you should register it before it's published. But go ahead with your foundation, Mr. White, and then we'll determine its admissibility.
Well, thank you, Your Honor. Dr. Cares, can you identify this document?
That is my curriculum vitae.
Your Honor, I now move that Exhibit A be admitted into evidence. The proper foundation has been laid.
Mr. Jane, any objection?
Yes, Your Honor, just one objection that Dr. Cares has not said that this is an authentic copy of his CV. So if Mr. White could lay that foundation.
Your Honor, this is the curriculum vitae for Dr. Cameron Cares. I can ask that question, but the doctor.
Well, I do think under the mock trial stipulations that it is included in the stipulation that it is authentic. So I'm going to overrule Mr. Jane's objection at this time, and it is admitted. Go ahead.
Thank you, Your Honor. Now, Dr. Cares, what education have you received in connection to your medical career?
Well, I went to Tufts University for undergrad in chemistry. Then I went to Bostonius University for medical school.
Any professional training?
Yes, I did an internship and a residency at Beth Israel Medical Center, and I did a fellowship at the University of Rochester.
And what professional associations do you belong to?
I'm a part of the American Gastroenterological Association, and I'm board certified by the American Board of Gastroenterology.
And what research experience do you have under your belt?
Well, I was a sub-investigator for multiple studies with digestive dysfunction. I was a sub-investigator for ClinSearch, and I was a sub-investigator in more than 10 therapeutic areas.
Your Honor, I now move that Dr. Cares be admitted and recognized as an expert witness in the field of gastroenterology and be allowed to give an expert opinion in that field.
Any objection?
No objections, Your Honor.
Dr. Cares will be admitted as an expert in the field of gastroenterology.
Thank you, Your Honor. Let's see, I believe I stopped sharing there. Now, Dr. Cares, tell the jury about what happened on September 5th.
Well, first I was paged for a GI consult with Bryson Saylor. He was complaining of swallowing a foreign metal object, so I did an x-ray, and then sure enough, there was a screw in my patient's stomach. So from there, I did an emergency endoscopic foreign body removal, and then followed that up with an esophagoduoendoscopy.
And did you do an x-ray on the patient?
Yes.
Your Honor, I now would like to share with the bench what has been marked as Exhibit E. I'll let the record reflect opposing counsel has a copy.
All right, before you publish it to the jurors or to the court, I'll ask Mr. Jane, is there any objection to the admissibility of Exhibit E?
No, Your Honor, no objections.
All right, go ahead. It'll be admitted as Exhibit E.
Thank you, Your Honor. So one moment. All right, Dr. Cares, can you identify and examine and tell the jury what this x-ray shows?
Mr. White, that shows a foreign body, in this case a screw, in the lower left quadrant of the stomach.
And can you describe what you did to retrieve the object?
Yes, so that was my emergency endoscopic foreign body removal, in which I put a scope down in the mouth, down into the esophagus, into the stomach. I retrieved the object and then brought it back up out of the oral cavity.
And can you describe the toll that this procedure takes on a patient?
Well, let me say it this way. The esophagus is only 2 centimeters wide. So when you are putting any kind of medical equipment like a scope down into the body, it is going to stretch the esophagus, and that can cause scraping, just overall some discomfort. So also we see the patient have some stress, bodily stress, that kind of a thing.
Objection, Your Honor.
What's your objection?
Pursuant to stipulation 12, this trial has been bifurcated, which means that the extent of damages is not an issue in today's trial. Now, I'm aware that Your Honor ruled on my co-counsel's previous objection that Mr. Saylor's testimony was admissible. However, that was admissible because Mr. Saylor was using that as evidence as per why he wouldn't put the screw or why he wouldn't swallow a screw intentionally. However, Dr. Cares is not offering this testimony for that purpose, and which is why it is inadmissible.
All right, what's your response, Mr. White?
My response is that pursuant to the plaintiff's burden of proof, we have to prove harm, and through this direct examination, that is what we are doing.
Response, Your Honor.
Sure.
Your Honor, the opposing counsel can certainly show harm by asking Mr. Saylor whether or not it was harmful, which they had already done on Mr. Saylor's direct examination. Dr. Cares is currently diving deeper into what potential harm an esophagogastroduodenoscopy can cause, which goes to the extent of damages, not the fact that damages occurred, which as per stipulation 12 is inadmissible.
Your Honor, may I respond?
Yes.
As opposing counsel just stated, we are going deeper into the harm that was spoken about in the previous questioning. And this is the doctor that oversaw Bryson Saylor, and this is the doctor that took care of him. So I believe it is important for the jury to get a full perspective on what happened on September 5th in order to make a correct ruling.
Very brief response, Your Honor.
What's that, Mr. Jane?
You're right. That Mr. White just said that he is, quote, diving deeper into the damages, which is expressly what stipulation 12 disallows.
All right, I'm going to sustain the. I'll allow you, Mr. White, to talk about some amount of harm because obviously there would have been some harm that occurred to Mr. Saylor, but not go to in depth with this doctor as you have. So let's move on.
Now, Dr. Cares, do patients often complain of pain after these procedures?
Yes, so that is why we will keep them about 2 hours after. And if they're complaining of pain after that, then we usually keep them overnight, that kind of thing. So yes, it is common.
And can you describe for the jury the discharge process that occurred with Bryson Saylor?
Yes, of course, Mr. White. So as I said, if they are still complaining of pain after the 2 hours, we will keep them overnight. Bryson was complaining of pain. So I kept him overnight, and then I discharged him on the next day, in which then after that, he came back about 3 or 4 times over the next 3 weeks, and he was still complaining of pain.
And so what did you do?
So I did some more x-rays. I did another esophagastroduodenoscopy. I just tried to give him some peace of mind because I know that after you've swallowed something and you know that you weren't supposed to, such as a foreign metal object like a screw, then I know that that can cause some emotional trauma, that kind of a thing.
Objection, Your Honor. I reinstate my stipulation 12 objection. Dr. Cares just dove into the potential emotional trauma that a patient might face, which would be inadmissible under the previous grounds.
Mr. White.
We will move on.
Go ahead.
Now, Dr. Cares, in your expert opinion, within a reasonable degree of medical certainty, did Bryson face harm by swallowing the screw?
Yes.
No further questions, Your Honor.
Thank you. Mr. Jane.
Yes, Your Honor. Now, Dr. Cares, I'd like to first start by talking about a couple of things that I'm sure we can both agree with. First, we can all agree that there was a screw found inside Bryson Saylor's stomach, correct?
Yes, Mr. Jane, we can.
We can also agree that, secondly, that Bryson Saylor claims to have swallowed the screw while eating a chicken sandwich, right?
Yes, we can agree on that.
Now, the jury's job today is to determine who put that screw on the chicken sandwich. The fact of the matter is, Dr. Cares, you actually don't have any medical evidence that could help this jury make that determination, right?
Well, I guess not. All that I know is that I pulled the screw out of Mr. Saylor.
Right, you talked about an x-ray that you took of Mr. Saylor, or of Miss Saylor on direct examination. Mr. Bueno, could we get that x-ray on the screen, please? While Mr. Bueno is putting the x-ray on the screen, nothing about the x-ray that you took of Miss Saylor could help this jury determine who put the screw on the sandwich, right?
Well, I assume not. As I said, all I know is that he did swallow it because I took it out of him.
Just to be clear, you also offer no medical opinions about who put the screw on the sandwich, right?
Objection asked and answered.
Response, Your Honor.
I'll allow the question. Go ahead, Mr. Jane.
Dr. Cares, just to be clear, you yourself don't offer any medical opinions to this jury that could help them determine who put the screw on the sandwich, right?
Not who, no.
Hey, well, Dr. Cares, I guess what I'm having a difficult time understanding then is why you're even here in trial testifying on behalf of one of your patients. I mean, let's be honest, isn't it true that you've stopped caring about your patients?
Oh, I did not
Your
stop
Honor.
caring.
Objection, Your Honor. Relevance and the beginning part of that question is out of the witness's testimony.
What's your
Response to the relevance portion, Your Honor, we're just trying to show a pattern of poor care that Dr. Cares takes towards his patients. It's directly attacking his credibility. And as per the outside of the witness's statement, I didn't say anything that was outside of his statement. I simply asked him whether or not he cares about his patients.
I understand, but given the pattern of questioning we've had thus far, I'm going to sustain the objection.
Thank you, Your Honor.
Are you saying the relevance portion or the
relevance? Yeah.
Yes, Your Honor. Dr. Cares, is it true that Dr. Cares, you are testifying on behalf of Bryson Saylor in today's case, right?
Yes, I am.
You've been unable to successfully leave your job at Poultry, right?
Objection, relevance.
What is the relevance?
Again, Your Honor, I'm simply trying to attack this witness's credibility. The fact that he is, I'm trying to show that Bryson Saylor is testifying on behalf of, that Dr. Cares is testifying on behalf of Bryson Saylor because he is a patient who is a board member who has donated in the past. And so for that reason, he is testifying on behalf of, or for Bryson Saylor.
Your Honor, I believe that the foundation for that has not been laid. And if opposing counsel would go into more detail as to what they're speaking about, that would be great.
Mr. Jane, I would agree that there's not really been a foundation laid for the relevance of that line of questioning, so I'm going to sustain the objection.
Yes, Your Honor. Dr. Cares, you received a raise after you treated Bryson Saylor, correct?
I'm not sure what that has to do with him, but I did.
And additionally, Bryson Saylor is a donor to the hospital, isn't that right?
He is. It's very generous of him to donate to our little hospital.
Furthermore, he's on the board of directors of the hospital, correct?
He is, yeah.
Now, you've also been unable to get other jobs, isn't that right?
Objection, relevance, and asked and answered as well.
Sustain the objection.
Dr. Cares, because Bryson Saylor is a member of the board's hospital, you wanted to give him the best care possible, isn't that right?
Oh, well, I give all of my patients the very best care. But I was aware, and as I said in my statement, my incompetent bosses, don't tell them I said that, but that they may, they probably would be more caring towards him, but that doesn't change how I feel about him. I treat all of my patients the exact same and with the best care possible.
Well, you're aware that your incompetent bosses, as you put it, their board member is here listening to your testimony and trial today, right?
I know, it's rough.
Dr. Cares, just a few last questions. You weren't present at Eat More Chicken on September 5th of 2019, were you?
One more time. I'm sorry. You cut out.
You weren't present at Eat More Chicken on September 5th of 2019, correct?
I was not. Believe I was performing a colonoscopy at that time.
Right, because of that, you aren't aware of any of the protesters that were present at Eat More Chicken on that day, correct?
Objection. This is out of the witness's testimony.
Response, Your Honor.
Yes, sir, Mr. Jane.
Your Honor, that's precisely the point. I'm simply asking whether or not Dr. Karras has knowledge of these events, and because she doesn't, that's the point I'm trying to get across.
Well, Mr. Jane, you've made your point that she really doesn't know a lot about how the screw ended up in his stomach. So I'm going to sustain the objection. It's not relevant to this witness.
Yes, Your Honor. Dr. Karras, just one last question. It's our contention in today's it's our contention in today's case that Bryson Saylor, the screw on Bryson Saylor's sandwich came from a chicken protester that placed it on there. Now, is there any evidence that you could offer this jury that could refute my client's contention?
No, Mr. Jane. All I know is I pulled the screw out of Bryson. That's why I'm here.
Your Honor, I object to relevance for the same reason as before. The witness was not there at the time.
What was the question, Mr. Jane?
I asked her whether or not she had any evidence that could refute a protester having putting the screw on the chicken sandwich.
I'll allow that question.
Thank you. Again, Dr. Karras, you have no evidence that could refute my client's contention that a protester was the one who put the screw on the sandwich, right?
No, Mr. Jane. As I said, all I know is I pulled it out of him, and that's what I've got.
Thank you, Dr. Karras. No further questions, Your Honor.
Thank you. Any redirect?
No redirect needed, Your Honor.
All right, go ahead and call your next witness, plaintiff.
The plaintiff calls Austin Biltmore to the stand.
All right, Mr. Biltmore's or Ms. Biltmore's been sworn. Go ahead.
Could you state your name for the court?
My name is Austin Biltmore.
And what do you do for a living, Ms. Biltmore?
I am currently working as a data analyst at Numbers R Us.
But what is your passion truly in?
I'm so glad you asked. I am currently a member of FTA, which stands for Free the Animals, and we are an organization that protests against the meat industry.
Now, what do you do inside FTA?
So, in the chapter that's been established, helped by me, in Poultry County, I am the lead sign designer, and I love making signs so much. I've converted half of my garage so that I can make signs.
Now, did you hear Bryson Saylor's account of what happened on September 5th earlier in this courtroom today?
I did.
Did Bryson Saylor's description of September 5th match up with what you saw?
Exactly.
Now, just to refresh the jury's memory, could you describe the protest that was taking place on September 5th?
On September 5th, about 20 FTA members gathered at Eat More Chicken, all wearing chicken costumes, because we find that that's the best way to grab the public's attention.
Now, was there anyone at Eat More Chicken that you noticed that day?
I noticed Drew Jennings and Bryson Saylor.
Now, who decided to take Bryson Saylor's order?
Drew Jennings did.
And could you describe how Drew Jennings handled taking Bryson Saylor's order?
He was really nervous and pushed the cashier over just to get to Bryson.
Now, who decided to deliver Bryson Saylor's order?
Drew Jennings did.
Could you describe how Drew Jennings delivered the order?
So he opened the sandwich, which I didn't see anybody else do, and he was fiddling with it next to his toolbox.
Now, did you see anyone else touch Bryson Saylor's food after Drew Jennings tampered with it?
No, I only saw Drew Jennings touch the sandwich.
Now, what happened after Drew Jennings tampered with Bryson Saylor's food?
He brought it to an empty table and then brought it to Bryson, and then I heard a lot of commotion coming from Bryson's table, and he sounded like he was in a lot of distress.
Objection, Your Honor. Relevance of the testimony that Ms. Biltmore said that Mr. Saylor sounded like he was in a lot of distress.
Mr. McQueen.
Your Honor, today we're here to evaluate the damages and respond in part to what opposing counsel claimed that Bryson Saylor could put this in his own sandwich. This evidence helped refutes the fact that Bryson Saylor would put this in his own sandwich as a moment of distress when it's just a sudden moment call, and it helps prove the burden of damage today in this court.
May I respond, Your Honor?
Yes, Mr. Roy.
One, Mr. McQueen is incorrect in that the amount of damages is not at issue in today's trial per stipulation 12. Second, the burden of establishing harm in a battery case has already been met. Mr. Saylor and Dr. Karras' testimony has already set the fact that Mr. Saylor has been harmed. Furthermore, throughout this whole trial so far, the defense has not yet claimed that Mr. Saylor served himself a screw. I'm not sure where the defense is getting that, or where the plaintiff is getting that.
I'll overrule the objection.
I'll re-ask you, Ms. Biltmore. Now, what happened directly after Drew Jennings delivered the tempered sandwich to Bryson Saylor?
I heard Bryson screaming, and he sounded like he was in a lot of distress and pain.
No further questions, Your Honor.
Thank you. Mr. Roy, any cross-examination?
Yes, Your Honor. May I have a moment to rearrange my camera?
Sure.
Good evening, Ms. Biltmore. I'm just here to ask you a couple of questions. Is that all right?
Good evening. Yeah, that's fine.
Ms. Biltmore, you would agree with me that you hate the meat industry, correct?
I would definitely agree with that. I am totally in support of saving every animal's life.
Exactly. In fact, you are part of an organization dedicated to shutting down the meat industry, right?
Exactly.
That organization is called Free the Animals, or FTA for short. Do I have that right?
Yes, that's right. We try to convert one meat eater at a time.
FTA organizes protests against restaurants that serve the meat-eating crowd, right?
That's right. FTA has actually protested Eat More Chicken and Sailorman's.
Exactly. You target restaurants that are popular with those same crowd, correct?
That's right. That's why we chose Eat More Chicken, because they had been popular for 2 months straight.
Exactly. And at these restaurants, you would agree that these protests are highly organized, correct?
I wouldn't say highly organized. We just gather people from our group that come and protest.
Well, you would agree with me that at these protests, you and your fellow protesters have a plan, right?
Just to scream and shout our lungs out.
That plan includes protest signs, right?
Yeah.
That plan includes chanting at specific times of the day, correct?
We usually try to chant at rush hour since that's when the most people are there.
Ms. Biltmore, this plan, it includes violence, doesn't it?
Objection, Your Honor. I just want to call for a bench conference.
All right. Now, parties approach.
Your Honor, what opposing counsel is about to go into is a direct violation of Rule 404A, in which character evidence is not admissible to prove conduct. And opposing counsel is about to go into an event that occurred in Miss Biltmore's college years. She is now in her early 30s. They are going to attempt to use this incident that occurred back then to prove that she would commit the same violent act on September 5th, which is inadmissible under Rule 404A.
Mr. Roy?
Your Honor, this testimony isn't precluded by 404A, as 404A is directed toward individuals, toward a person, as the rule states. FTA is an organization. This line of testimony is going toward FTA as a whole, which does not fit the 404A.
What time frame are you talking about, Mr. Roy? The testimony you're eliciting.
This testimony is regarding actions previously in the past, but are still relevant in today's trial.
All right. Any response, Mr. McQueen?
Yes, Your Honor. Ms. Biltmore can't speak on behalf of the entire Free the Animals organization, as she's just part of a local chapter, so it would be directly asking her for her actions. And this directly goes into an event that happened in her college years. She is now in her early 30s. And so that event would be trying to prove character evidence to prove conformity that she would commit a violent act again today, like years and years and years afterwards, after her college experience.
Thank you. I'll sustain the objection.
Yes, Your Honor.
Thank you, Your Honor.
Ms. Biltmore, on September 5th, 2019, you and your FTA protesters were present at Eat More Chicken, correct?
That's right.
And on that same day, Mr. Bryson Saylor received a screw in his chicken sandwich, correct?
Yes, that's correct.
I'd like to talk about your relationship with Mr. Saylor.
Okay.
You don't like him very much, do you?
No, but I mean, it's hard to like somebody when they eat chicken. I mean, they're just innocent animals, you know?
You'd go so far as to call him a jerk, right?
Yes, I've called him a jerk and a bully.
Exactly. And you believe that bullies should be stood up to. Do I have that right?
That's correct, but I didn't have any need to since Drew already did.
You and your fellow protesters have targeted Mr. Saylor in the past, correct?
We actually protested at Sailorman's and he asked us to leave the premises.
He didn't just ask you to leave, Miss Biltmore. He pressed charges and threatened to sue you all. Do I have that right?
That would be correct.
That made you angry, didn't it?
I can understand his point of view, but we just butt heads, you know, him being a chicken lover and all.
So that was a yes, that you did become angry when he pressed charges.
Yes.
And on September 5th, 2019, you saw Mr. Saylor at Eat More Chicken, right?
That's correct. I wanted to talk to him about the possibly not chicken sandwich. I'm convinced that anybody who eats it would absolutely fall in love.
You believed that it was a fate opportunity that you just couldn't pass up. Do I have that right?
Yeah, to talk to him.
Now, Ms. Biltmore, you are aware that on September 5th, Mr. Saylor ingested a 1-inch galvanized screw, right?
I'm aware of that.
And on that same day, that same protest, you and your fellow protesters carried protest signs, correct?
That's correct.
You, in fact, are in charge of those same protest signs. Do I have that right?
Yes, I love making them. I make catchy phrases like the one on September 5th read, "Free the chickens."
And those protest signs that you made, they were made with 1-inch galvanized screws. Do I have that right?
I find that those are the perfect size for my signs.
On September 5th, 2019, you also saw a sandwich all alone at a table. Do I have that correct?
Yes, that would be the sandwich that Drew delivered to Bryson, but I did not touch it. I just had a moment of silence for that poor chicken that had to die for him to eat.
You would agree with me that you went up there and stood right next to that table containing Mr. Saylor's sandwich, right?
Yes, that's correct.
When you were there, Mr. Jennings was nowhere near you, correct?
Actually, he was just a few feet away from me, and he brought the sandwich back to Bryson a couple moments later.
Is it your testimony to this jury that Mr. Jennings was near you when you stood by that sandwich?
No, but I know where he was. He was in the restaurant with me.
And to repeat my question, Ms. Biltmore, you do not know where Mr. Jennings was when you stood by that sandwich, right?
Actually, I believe he had gone back to the register.
Perhaps I should clarify. You, Mr. Jennings, you do not know if Mr. Jennings saw you as you stood next to that sandwich, right?
I don't know.
Exactly. Thank you, Ms. Biltmore. No further questions, Your Honor.
Thank you. Any redirect?
Yes, just a short redirect, Your Honor. When you were praying over that chicken sandwich, did you ever touch it?
Absolutely not.
Did you see anyone else ever touch Bryson Saylor's sandwich?
No, I only saw Drew touch the sandwich.
And did you put a screw in Bryson Saylor's sandwich?
No, I believe that change comes through peace and understanding.
No further questions, Your Honor.
Any recross?
No recross, Your Honor.
All right, you may step down. Would the defense like to call a witness next? This is a plaintiff resting its case.
Yes, Your Honor. At this time, the plaintiff does rest.
Thank you. Are your first witness, Mr. Smith?
Your Honor, the defense calls the defendant Mr. Drew Jennings.
Mr. Jennings has been sworn. Go ahead when you're ready.
Mr. Jennings, can you see and hear me all right?
Yes, sir, I can.
All right. Now, would you please introduce yourself to the jury and spell your last name for the record?
I'm Drew Jennings, and it's spelled Jennings.
Now, the jury has heard testimony today that you're the owner of the Eat More Chicken restaurant. Is that true, Mr. Jennings?
Yes, sir, it is.
And have you been present to listen to all the testimony that's been given throughout today's trial?
Yes, sir, I have.
did you hear the plaintiff's accusations that you intentionally served him a 1-inch galvanized deck screw in his chicken sandwich?
I know that's what he's claiming, yes.
Mr. Jennings, I want you to tell this jury, did you place a 1-inch galvanized deck screw in the defendant's sandwich? Plaintiff
No, no, I did not. It's completely untrue. I would never hurt one of my customers. Look, believe me, I feel awful about what happened to Mr. Saylor, but I didn't do anything to hurt him.
Well, when you handed the plaintiff his chicken sandwich, did you have any reason to believe that it was contaminated?
No, not at all. I mean, it just doesn't make sense. There's no way I would ever serve a customer a sandwich with a screw on it. That would be like sabotaging my own restaurant. I mean, why would I do that? I didn't open a restaurant for people.
Well, when the plaintiff walked into your restaurant that day, did you have any reason to be upset with him?
To be upset with him? No, not at all. I mean, I didn't even know Mr. Saylor at that point, at least not personally. Of course, I'd seen him on all the Sailorman's TV commercials, but that's it.
So had the two of you ever even met before?
No, never.
All right, well, you told this jury earlier that placing a screw in your own restaurant's food would be like sabotaging your own business. Would you tell this jury what you mean by that?
Yes. I mean, look, at this point, we had been open like 3 months, not even that. I mean, it's a big investment and we're competing for customers. We're working like heck to build up our reputation to become a part of the community. So to put a screw on a customer sandwich on purpose, well, that's just a recipe for financial disaster.
Mr. Jennings, is it true that when Mr. Saylor approached the cash register, you were the one who took his order?
That is true. I saw Mr. Saylor come in and I didn't know why he'd be there. So I didn't want him trying to get our customers to go to his restaurant or something. So I decided to wait on him.
Is it also true that you were the person who delivered the plaintiff his chicken sandwich?
Yes, sir, it is.
So if you were the one who delivered the sandwich and you were the one who took this Mr. Saylor's order, was the plaintiff's chicken sandwich ever outside of your control?
Yes, the sandwich was outside my control right before I served it. So I was bringing out Mr. Saylor's food on a tray and I realized that I'd forgotten the napkins. So I set down the tray on an empty table and I went back to the counter to get some napkins.
And what did you do next?
Well, when I returned, I realized that the bun on top of the sandwich had been moved from where it was before. Instead of being square on top like I had it, it had been shifted to the side. I mean, at the time, I didn't think much of it, but looking back now, it seems pretty important.
What did you do after you returned to that table?
Well, I mean, I had no reason to believe that it had been tampered with, so I straightened up the bun and I served it to Mr. Saylor.
Okay, well, regarding who might have had the opportunity to tamper with that sandwich, did you see anyone near the table that you put Mr. Saylor's tray down on?
Yes, our restaurant was targeted by a group of protesters that day. They object to any businesses that sell meat, and they were all over the place waving signs and yelling. And one of the protesters, Miss Biltmore, who talked earlier, she was right next to the empty table where I put the tray down.
Okay, now regarding these chicken protesters, did you know who the protester, Miss Biltmore, and her group of protesters was protesting against?
Yes, they're animal rights activists. Like I said, they object to any businesses that serve meat. Like Miss Saylor said, it got so bad for her that she had to have some of them arrested. And frankly, if one of them had an opportunity to harm Mr. Saylor and have me and my business take the blame for it, well, there you go.
You just said that these protesters were trying to disrupt your business. Was your business actually disrupted by this incident?
Yes, very much so. Our sales are off the proverbial cliff, and that was before the pandemic. I mean, I don't know if we're going to make it. This stuff has been all over the media, and believe me, it's not true when they say that all publicity is good publicity. Who's going to want to get
it? All of that was out of the witness's testimony?
I think it is rationally related to something that he can infer, so I'll overrule the objection.
Mr. Jennings, I was asking you if these protesters disrupted your business.
Yeah, like I said, our sales are off the proverbial cliff. I mean, who's going to want to eat at a restaurant that they think serves people screws in their food? I mean, that's just why it doesn't make sense for me to do this to my own restaurant on purpose and to throw away my dream.
Okay, well, let's return to Austin Biltmore, the protester dressed in the full chicken costume. Had you seen her at any other point that day?
Yes, I remember seeing her in line right behind Mr. Saylor when I took Mr. Saylor's order. And then, of course, the next time I saw her was next to Bryson Saylor's food.
Okay, Mr. Jennings, when you returned to the tray that you put Mr. Saylor's table, Mr. Saylor's tray down on, and you saw the protester standing there, Ms. Biltmore, what did you do next?
Well, I just picked up the tray and served it to Mr. Saylor. And next thing you know, he's yelling and screaming about something being wrong with his sandwich, that there was a nail and all that.
What did you do at that point?
Well, I really didn't understand what was going on, but I was concerned for Mr. Saylor, so I offered to drive him to the hospital. But he turned me down, and I guess he drove himself to the hospital.
Now, Mr. Jennings, Austin Biltmore testified earlier about a box. Mr. Saylor's chicken sandwich was in a box that you touched. Does Eat More Chicken serve their chicken sandwiches in boxes?
No, I don't know where that's coming from. Our food has always been served on trays, just like they were that day. I'm not sure where she's getting this information.
Was there anything else you would like to tell this jury, Mr. Jennings?
Yes, I'd just like to say again that I did not put a screw in Bryson Saylor's sandwich. I would never hurt one of my customers.
Thank you, Mr. Jennings. Nothing further, Your Honor.
Thank you. Mr. White, cross-examination.
Yes, Your Honor. Good evening, Mr. Jennings. My name is Trent White, and I'm going to be asking you some questions.
Good evening.
Now, you opened up your own Eat More Chicken franchise in your hometown of Poultry, Tennessee. Am I right?
That's right, in June of 2019.
And since the beginning, business has been successful.
Well, it was successful until this event that we're here today to talk about.
You've even been told that Eat More Chicken was the new Chicken King, haven't you?
I remember seeing some social media talk of that, yes.
And you would believe that, correct?
I mean, at the time, we certainly were doing well. Right now, not so much.
And you said in your statement, some individuals seem to be jealous of your success.
Yeah, I guess so. I suppose that comes with an amount of success. Yes.
Now, Bryson was one of your only business competitors in poultry. Am I right?
That's right. He's one of several business owners that serves chicken like Eat More Chicken does.
And he's the only individual you mentioned in your statement.
I believe so. The only one by name, yes, sir.
Now, on September 5th, moving on, you were fixing a picture that had fallen, correct?
That's right. In the back of the restaurant by the restrooms, I was fixing a picture. Yes, sir.
And you were using a toolbox to with items to fix the picture, correct?
Yeah, that's right. I had a toolbox and a hammer and some nails. Yes, sir.
Mm-hmm. Your Honor, I would like to bring to the attention of the court that according to admitted stipulations, Drew Jennings' toolbox contained an inventory of items, including an ACE number 6x1 inch L Phillips bulgehead galvanized deck screw.
All right, so noted.
Thank you, Your Honor. Now, after you were fixing that, or while you were fixing that picture, you were notified of Bryson Saylor's presence.
That's right. My employee, Ryan French, told me of that. Yes, sir.
And you rushed to take Bryson's order.
Yeah, that's right. I didn't have time to put the toolbox away. I just left it there and went to take his order.
Mm-hmm. And you took only Bryson's order?
Yeah, that's right. Obviously, since Bryson's a competitor, he's an important customer, and I wanted to take his order for presentation purposes.
Mm-hmm. And you told Bryson Saylor that he'd received the freshest, hottest chicken sandwich available, correct?
That's right. It was my intention to give Bryson Saylor the best service possible.
And you were the one to check Bryson's order, correct?
Yeah, that's right. I made sure that we had gotten the right items after it was prepared in the kitchen.
Made sure it was correct.
Yes, sir, that's right.
And at that time, you were fully and 100% responsible for Mr. Saylor's order, correct?
I suppose at the time I checked the order, but like I said, I certainly wasn't responsible for it when I left it on that table.
And you went to take the plaintiff's food out to him, correct?
That's right.
But you, as you've recalled, you didn't make it all of the way to Mr. Saylor's table, did you?
Yes, unfortunately, we had forgotten the napkins, so I had to set it down on that empty table to go get some at the counter.
So you left it on the empty table
That's right.
in a crowded restaurant
Yes, sir.
to grab some napkins.
That's right.
And when you returned, you took the sandwich out to Bryson.
Yeah, I took the tray to Bryson Saylor. Yes, sir.
But before that, you noticed that the bun had slid off. So you fixed it, correct?
Yeah, that's right. Unfortunately, the bun had been moved off, and I had to fix it. But yeah, unfortunately, I didn't think much of it at the time.
Mm-hmm. And you proceeded to take that chicken sandwich, which was left alone in a crowded restaurant, out to Mr. Saylor, correct?
Yes, and looking back now, it wasn't the right decision. There were plenty of protesters there, and I should have thought better.
And Bryson tried the sandwich, didn't he?
I guess so. Yes, sir.
And then after that, you heard Bryson yelling that something was wrong.
That's right. He was complaining that something was wrong with the sandwich.
And you tried to calm the situation, didn't you?
Yeah, I tried to help Mr. Saylor. I offered to drive him to the hospital. One of my employees offered to call an ambulance, but he made it clear he didn't want our help.
Mm-hmm. And so, yeah, so Bryson did leave the restaurant.
Yes, after that, Bryson did leave. Yes, sir.
Now, you are active on Twitter, correct?
I do have a Twitter account. Yes, sir.
And that Twitter account is @#1chickenfan?
Yes, sir.
And I would like to bring back to your attention that Bryson was your only main business competitor, correct?
He was one of several competitors, but Sailorman's is a successful business. Yes, sir.
You never said in your statement you had any other competitors, correct?
I didn't mention any others, but there are plenty of competitors in poultry. Yes, sir.
So you didn't mention it in your statement. And Your Honor, I now would like to share with the bench what has been marked as Exhibit D. Let the record reflect opposing counsel has a copy.
Is there any objection to the admissibility of Exhibit D?
Your Honor, I object to part of Exhibit D. As to the messages in gray, I have no objections there as they are admissible by party opponent. But as to the messages in gray, as they were sent by Mr. Saylor, party opponent does not apply since Mr. Saylor's own party is offering this into evidence. So I do object to the hearsay of those statements.
What's your response, Mr. White?
Your Honor, Mr. Saylor already testified in direct examination earlier that he was the author of this account. He had this account, and therefore these are his messages.
Why should they be admitted just on that, Mr. White?
And what was the objection? Once again, I'm sorry.
You can restate your objection.
It was hearsay to the messages in the gray bubbles sent by Mr. Saylor.
All right. I'll overrule the objection because I think it puts it into context to have the admissibility by each party. So if it's only the two parties, Saylor and Jennings, in the messages, I'll overrule the objection.
Yes, Your Honor.
Thank you, Your Honor.
You're welcome.
All right. So may I share with the bench?
Yes, you can publish it and it'll be received and admitted as Exhibit D.
Just one moment. Let's see here. All right. Can everyone see that?
Yes.
All right. Now, Mr. Jennings, you didn't respond first in these messages that we see here today, correct?
That's right. This person, he initiated the conversation.
Mhm. And he said, "Hey, I know you're stealing my business and you better stop."
That's right. That's what it says. Yes, sir.
And you sent some question marks and said, "Don't have any idea what you're talking about. SMH, shake my head."
Yes, sir. That's right.
And so after this, Bryson sent a GIF of two chickens. It looks like here arguing, correct? And after that, he said, "Balk off, you're going down." Is that what you see?
Yeah, that's right. There appears to be some kind of violence between the chickens. Yes, sir.
Right. And I mean, that looks like a very intense chicken fight. I do say so myself.
Objection,
And
Your Honor. I ask that the court disregard counsel's last statement.
Overruled.
thank you, Your Honor. Now you saw that GIF and he said, "Balk off, you're going down." And then after that, you said, "I think you're just jealous. There's a hashtag new Chicken King in town," correct?
That's right. Yes, sir.
Now, on September 4th, the very last message you ever sent to Bryson Saylor was a message of you saying, "Going to enjoy watching your chicken kingdom crumble." You said that. Am I right?
That's right. I meant it in a lighthearted sense. Of course, I didn't know that these protesters were going to come after Mr. Saylor.
And so, in direct examination a moment ago, you said that you had no reason. You had no reason to harm Bryson Saylor, correct?
Yes, and I have a reason not to as well, because it would be a financial disaster for my business.
So you wouldn't wish any harm on Bryson.
Of course not.
But in your statement, you called Bryson ruthless, correct?
Yeah, I mean, he's a ruthless businessman, and that's what he's known to be around town, but that certainly doesn't mean I would wish harm upon him.
You called Bryson shady.
That's right. He's known to be a little shady in his business dealings. Yeah.
You called Bryson ruthless, you called Bryson shady, and you called Bryson dramatic. Am I correct?
That's right. He was, in my opinion, being a little dramatic that day until I realized what the protesters had done and that he was actually in pain.
And after Bryson left, when he was not in your presence, you said that you hoped Bryson was okay. But you didn't stop there. You continued and you said, "Even if people think he is a bully and got what he deserved." You said that, right?
Right. Up until I opened my restaurant, Bryson had never really had a competitor, and that's what I believe he deserved, was a competitor in the free market. I certainly didn't know that there was a screw in a sandwich that day, and looking back now, I can see how it could be taken out of context.
Mm-hmm. And in that statement, you called Bryson a bully.
Yeah, I said that some people around town think he's a bully, yes.
No further questions, Your Honor.
Thank you. Mr. Smith, any redirect?
Briefly, Your Honor. Mr. Jennings, was there a 1-inch galvanized deck screw in your toolbox on September 5th of 2019?
I don't know. I don't keep inventory of my toolbox, so I know there's a hammer and nails, but as for screws, I'm not sure.
Nothing further, Your Honor.
All right. You may step down. Call your next witness.
The defense calls Ryan French. Good evening, Ryan French. Mr. French, can you see and hear me okay?
Yeah, it's all good on this end, yo. I got you loud and clear.
That's perfect. Will you please tell us your full name and spell your last name for the record?
Yeah, it's French. Ryan French. Man, that's French.
How old are you, Mr. French?
Man, I'm 26 this year, yo.
Where are you from?
From right here, yo. Poultry. Yeah, grew up here all my life. Down that south side by the railroad tracks, you know what I'm saying? Man, ain't nothing come easy over there, yo. But man, I got my diploma. I'm on the rise now. Working for Mr. J.
When you say Mr. J, are you referring to the defendant, Drew Jennings?
Yeah, you know him, Mr. J. I mean, look, he's been helping me with all those ropes at the Eat More Chicken, you know what I'm saying? Like, he's like some guru or something, man. Chicken Man of the Year and all that.
So are you a manager at Eat More Chicken?
No, mind you. I'm the manager, okay? So man, other than Mr. J up there, I'm the one that's steering that boat, okay? I mean, I've been working in fast food since I was like 16. Man, if I continue this way, I might get my own restaurant someday, you feel me? I mean, you might see me follow Mr. J's footsteps one day, yo.
Now, Mr. French, were you present at Eat More Chicken on September 5th, 2019?
Yeah, man. Like, look, if we're open, I'm gonna be there, all right? In fact, I'm in the back room right now on a break, yo.
Now, we heard testimony. Excuse me, Your Honor, I believe the lights just went out.
Things happen.
So sorry about that. Now,
Right.
Mr. French, we heard testimony about a group of protesters present at Eat More Chicken on September 5th. Did you see these protesters?
Shoot, man, did I see them? Yo, they were everywhere, okay? I mean, like, they were all over waving signs, protesting, saying we shouldn't be serving meat. I mean, yo, how are we gonna serve chicken at Eat More Chicken without meat? Don't even make sense, yo.
Did you do anything when you saw these protesters?
I mean, yeah, man, like, as manager, I had to, yo. I mean, I had to go out there. Basically, everyone was on our front lot and people couldn't get in, man. So, man, I had to tell them, shouldn't say exactly what I told them because I didn't want to get in no trouble with no judge now, right? But basically, I told them, like, get on out of there so that people could get in the restaurant, yo.
Do you remember seeing a protester in a full chicken costume?
Shoot, man. I mean, look, I seen some stuff on the south side where I grew up, but man, a full-grown chicken woman? Like, I'm talking feathers, beak, little orange feet, you know what I'm saying? People be tripping these days, yo.
Do you remember where this protester was when you first saw her?
Yeah, like, she was headed back in the restaurant about like the same time I was.
Mr. French, as you and the protester went inside, did you see the plaintiff, Bryson Saylor?
Yeah, like that was the first time I saw him, yo.
Do you remember where Mr. Saylor was standing?
Oh yeah, back of the food line.
Before you went outside to move the protesters away from the entrance, had you seen Mr. Saylor in the restaurant any time before?
Anytime before that, I mean, like went out, man. Let me think on that. That was the first time I saw him, yo.
Now, as you and the protester went inside, did you hear the protester say anything?
Did the chicken talk? Yeah, I heard the chicken talk.
Please tell this story.
Objection, Your Honor.
What's your objection?
I'm sorry, I just got kicked out, so I'm sorry if I'm a little laggy, my Chromebook crashed, but this is hearsay.
What's your response, Mr. White?
Your Honor, so I believe Mr. French is going to say that the statement was, fate had given me an opportunity that I can't pass up. We are not using the statement to prove the truth of the matter asserted. The defense is not trying to assert fate had indeed given someone an opportunity. That is not what.
Sustain the objection and strike the attorney's comments from the record.
Thank you.
Mr. French, what happened afterwards?
Yo, like, chicken woman's going in, right? And man, like that's right behind Mr. Saylor. So man, I see Mr. Saylor there, and I have to go back and tell Mr. J, right? It's the right thing to do. I mean, like, as soon as I tell Mr. J, he went to go personally serve him, yo. I mean, that's the type of great service we're proud of here at Eat More Chicken, you know what I'm saying?
What was Mr. Jennings doing when you told him this?
Oh man, he was like hanging up a sign for sweet potato spice coffee, if you can believe it. I mean, yo, soccer moms dig that, you know what I'm saying?
What happened, or excuse me, Mr. French, this may come across as a bit weird, but do you remember seeing any screws in Mr. Jennings' possession that day?
Screws? Man, look, I mean, he was hanging up signs, but that was with a hammer, you know what I'm saying? Not a screwdriver.
What happened after you told Mr. Jennings this?
Well, for me, I just went back to doing my job, you know, wiping down tables, giving that dining room that shine that it needs. I mean, all of a sudden, though, like, I just hear Mr. Saylor just like all about his sorts about some nail in his food or whatever.
Did you go to help Mr. Saylor?
I mean, yeah, man, like anybody would. I have to go. Okay, I went right over. I have to call 911, get an ambulance up in here. Man, he refused.
How did Mr. Jennings react to all of this?
Mr. J? I mean, just like you would expect, yo. He ran right over, offered to drive Mr. Saylor to the hospital himself.
Did Mr. Saylor accept Mr. Jennings' offer to personally drive him to the hospital?
That's a negative, yo. He just got up, man, he walked straight out the restaurant.
After Mr. Saylor declined your offer to call 911, Mr. Jennings offered to drive him. Did you ever find out what hospital Mr. Saylor went to?
Oh man, I didn't know about none of that until all these lawyers started calling or whatever.
Thank you, Mr. French. No further questions, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. So I heard you earlier, Mr. French and Direct, say that you didn't see any screws in in Miss Jennings' toolbox.
Ah man, nowhere to be seen, yo. I mean, I didn't even see no toolbox, you know what I'm saying?
Are you aware that, according to stipulations, that there was a screw found in discovery afterwards?
Objection, Your Honor. My witness lacks personal knowledge about the stipulations in today's case. Those stipulations are only made aware to the lawyers and to the parties involved, which is Mr. Drew Jennings and Mr. Bryson Saylor.
Your Honor, could I respond?
Overruled. You can still ask that question. Go ahead.
Were you aware that there was a screw found in discovery?
Oh man, I didn't know none of that.
But the toolbox wasn't the only thing that you were having trouble seeing that day, was it?
Slow down. What?
The toolbox wasn't the only thing that you were having trouble seeing that day, now was it?
I was having trouble seeing something, you're saying?
Yeah, in your statement, you said that you thought you were having hallucinations.
Yeah, man, okay, I thought I was hallucinating because, look, these chicken protests, have you ever seen any of these? Look at this, man. I was so surprised. I mean, I thought I was hallucinating, but man, I wasn't.
And these hallucinations I actually came from you being tired and overworked?
I mean, I was Avery didn't show up, you know what I'm saying? I had to be working 3 things at once, you know. It was hectic, you know what I mean?
No, so speaking of Avery, Miss Jennings actually got mad at Avery in the morning, is that correct?
I mean, yeah, he showed up super late, you know what I'm saying?
And Miss Jennings is actually known in the community to have a bad temper, is that correct?
I mean, yeah, some people call it that.
Now, you actually have a good relationship with Miss Jennings, isn't that correct?
I mean, yeah, you can say that. Look, he pulled me out of that Mickey D's that I was working at, yo. I was flipping burgers, but man, look at where I am now, yo. I'm on that rise.
And when you got hired that day, you wanted Miss Jennings' signature, is that correct?
I mean, yeah, if I wasn't in such a rush, yo, I mean, I would have gotten her signature because, man, I could have sold that for some moolah, you know what I'm saying?
And you also said that people would do anything to have the opportunity to work for Miss Jennings. Is that correct?
Yeah, I believe anyone would. It's such a good boss that he is.
So Miss Jennings is something of an idol for you. Is that correct?
I mean, I don't praise the Lord Jesus to her or anything like that, but I mean, I look up to him.
But he is a personal mentor for you. Is that correct?
Exactly, yo. I mean, look, he's taught me a lot of stuff that I can use in my daily life. You know what I'm saying?
Now, later on September 5th, Drew Jennings was already in a bad mood when you saw Bryson Saylor enter Eat More Chicken.
I don't know, man. I just saw him hanging up signs. You know what I'm saying? I don't know what mood he was in, but
this was later in the day after he got angry at Avery Andrews.
I guess that was after that.
Yes, afterwards. And when Bryson Saylor entered the store, Drew Jennings was very set on being the only one to take his order, correct?
Yeah, man. Look, he told me he wanted to personally serve him, yo. Give him that Eat More Chicken love we're talking about here, yo.
And you had mentioned that you figured that Bryson Saylor was maybe there to cause problems. Is that correct?
I mean, yeah, I just didn't want nothing to happen, you know what I'm saying? I knew him from all those commercials.
But yeah, in fact, you'd never met Bryson Saylor, had you?
Exactly. I knew him straight from those commercials. I never met him personally.
So you are here today testifying about a man in part that you've never met?
I mean, yeah, I never met him.
On a day that you felt very overworked and tired and even said that you thought that you were hallucinating?
Okay, I only thought I said I was hallucinating just because I mean, look, I never seen no chicken protester in full chicken costume, yo. I
And
wasn't too,
testifying
I
on
wasn't
the
too
same
overworked,
side?
you know what I'm saying?
And testifying on the same side as your mentor?
Look, I was just called in to answer some questions. Man, that's what I'm doing right now.
But you are on defense, is that correct, sir?
I mean, you call it whatever side you want, but whatever.
And Drew Jennings, your mentor, is also on defense?
I guess. I mean, I don't know.
No further questions today, Your Honor.
Thank you. Any redirect?
Yes, Your Honor, brief redirect. Why are you here today, Mr. French?
Like I just said, yo, lawyers called me. Man, they wanted me to answer some stuff about this case or whatever. That's all I'm here for, yo. I'm just giving what I know.
Did Mr. Jennings being your personal mentor affect any of your testimony today?
No, man. Look, I'm just saying stuff from inside the heart, you know what I'm saying?
Thank you, Mr. French. No further questions, Your Honor.
Any recross briefly, Mr.
No, Your
McQueen?
Honor.
All right, call your next witness.
Your Honor, the defense calls Mr. Taylor Tarr to the stand.
Mr. Tarr has been sworn. Proceed when you're ready.
Before we begin, Mr. Tarr, can you see and hear me all right?
Yeah, sure. I can hear you real good.
Could you please introduce yourself to the jury and spell your last name for the record?
Sure. My name is Taylor Tarr, and you spell it Tarr.
And what do you do for a living, Mr. Tarr?
Well, I'm an accountant, a professional bean counter, as they say.
Are you from around here?
Well, my ma is a sixth-generation Tennessean, so I was born here, you know. But Pops, he was from Brooklyn, so we moved back up there, well, when I was a toddler, so I grew up in the city.
When did you move back to Tennessee?
Oh, geez, don't get me started. Summer before my senior year, for crying out loud. I mean, what a time to move a guy, huh? Anyways, graduated high school here. Even got voted most congenial, if you can imagine that. I mean, that's gonna be a first for a New Yorker. You know what I'm saying?
Did you attend college after graduating high school?
Yeah, sure. I stayed in Nashville and studied accounting.
And did you receive a degree in accounting?
Yeah, I got my bachelor's. Got some money gigging over at that Zany's Comedy Club. I mean, I was having so much fun, I decided to stick around and get my master's while I was at it.
Where do you currently work as a professional accountant?
Well, I opened my own accountant firm, actually. I'm a small-time business owner these days. Gives me the freedom to make my own schedule, you know?
Mr. Tarr, I'd like to turn our attention to why you've been called to trial today. Now, are you aware of a man named Bryson Saylor?
Sure, I know Mr. Saylor. He's good people.
How do you know Mr. Saylor?
Well, he's a friend of mine and also a client. I crunched the numbers for his chicken restaurant, Sailorman's.
How well would you say you know Mr. Saylor?
Well, I know him pretty good. I mean, this town ain't that big, and our families have practically known each other forever.
Are you aware that Mr. Saylor has sued a competitor claiming that he was purposely fed a metal screw?
Yeah, sure, I heard about that. I mean, that's why I'm here, right? Yeah, I had heard that Mr. Saylor had sued that owner of that new Eat More Chicken place. I can't say I'm surprised.
Mr. Tarr, why do you say that Mr. Saylor suing Eat More Chicken's owner doesn't surprise you?
The
No
number.
objection, Your Honor. Relevance.
What's your response, Mr. Jane?
Your Honor, Mr. Tarr is simply giving a lay witness opinion about the events as he saw them. He's about to go in depth as to why he thought or why he believes Mr. Saylor suing Eat More Chicken's owner didn't surprise him.
Your Honor, if I may, what Mr. Tarr is about to go into isn't about the events that he saw on September 5th. He's about to go into why he's surprised about this lawsuit at all, which is completely irrelevant, especially due to the fact that Mr. Tarr is not a professional witness, not an expert witness. So it does not provide any real matter to the case today.
I'll sustain the objection.
Mr. Tarr, could you explain the financial statements of Mr. Saylor?
Yeah, sure. Mr. Saylor's financials were down 25%.
What did you think after you saw this on the financial statements?
Well, I mean, the first thing I thought was, for the love of Mike, why me, right? I mean, 25% is no joke. And I knew I was the one who was going to have to break the bad news to him. So I wasn't looking forward to it.
Did this 25% decrease in sales occur before or after Mr. Jennings opened up Eat More Chicken?
These drop in sales happened after Mr. Jennings opened up Eat More Chicken.
Did you tell Mr. Saylor about his decrease in sales?
Yeah, sure. I mean, I communicate with all my clients, good or bad. I mean, I guess you could say I have an ethical obligation to let every single one of them know what's going on. And Mr. Saylor is no different.
How did you tell Mr. Saylor about his decrease in sales? Was it in person or in some other way?
We met face to face. When it comes to breaking the bad news to people, I find doing that kind of stuff is best done in person, It's better for everybody that way.
Could you tell the jury how Mr. Saylor reacted to hearing that his sales were down 25% just after Mr. Jennings opened up Eat More Chicken?
It wasn't good. He was screaming and yelling and all that, and then he just stormed out of my office.
Did he scream anything in specific?
Yeah, sure. I just decided to give Mr. Saylor some space after breaking the bad news to him. So I went over to the copier to go get some copies. But when I come back, I hear Mr. Saylor screaming, "Ain't nobody come after my business."
Did Mr. Saylor scream anything else?
Yeah, actually, he said he was gonna put a stop to it.
What did you think after you heard this?
Well, I didn't know what to think, really. But then I heard about this lawsuit, and everything makes a lot more sense.
Mr. Tarr, did Mr. Saylor file this lawsuit before or after that phone conversation took place?
Before or after? To be honest, I don't know when this lawsuit was filed, so I couldn't tell you.
Did this phone conversation take place before or after October 31st of 2019?
October 31st. Yeah, it was September when I broke the news to Mr. Saylor. So definitely before October 31st, and definitely before this case, if that's when it got started. Again, everything makes a lot more sense now.
Thank you, Mr. Tarr. No further questions, Your Honor.
Thank you. Mr. Schultz?
Yes, Your Honor. Hi, my name is Daniel Schultz. How are you this evening, Mr. Tarr?
I'm good, sir. How are you?
Good. Now, Mr. Saylor is one of your clients, correct?
Yes, Mr. Saylor is one of my clients.
And so you told Mr. Saylor about his sales report on September 5th, right?
Yes, I had notified him about his drop in sales.
Now, is 25% a large margin when dealing with sales reports?
I'd say yeah.
Right, so and Mr. Saylor was upset about his sales being down 25%, isn't that right?
Yeah, I mean, he was screaming and yelling in my office.
And these are his sales report that were down again by 25%.
Yeah, Salem's sales were down 25%.
Right now, later on September 5th, you overheard Mr. Saylor, right?
Yeah, I had overheard him talking in my office.
Right, and can you tell us today who Mr. Saylor was speaking with?
No, I can't tell you exactly who he was speaking to, no.
So you're not exactly sure who Mr. Saylor was having a conversation with, if at all, with anyone?
Well, I mean, I'm pretty sure there was nobody in my office, but, I can't be for certain.
Right. Now, earlier you called Mr. Saylor a friend, right?
Yeah, Bryson and I, we go way back.
You also called him ungrateful in your statement, right?
Yeah, Bryson, he had missed out on, giving me a bit of a bonus, which, I thought I deserved. But, Bryson's a good guy all around.
Right, a good guy, but you were upset about not receiving an end-of-the-year bonus.
Yeah, I was a bit irritated, but it's in the past.
Right, but when it happened, you said sometimes what comes around goes around, right?
When I had said that, I was referring to how it's kind of funny that, Mr. Saylor, didn't give me that bonus. And then this new Eat More Chicken business comes around and, gives him a run for his money.
Right, and Mr. Tarr, just to clarify, you're here testifying on behalf of the defense?
Am I? I don't really know. Some lawyers just called me and said I had to answer some questions here.
Right, and you're testifying for the court today against Mr. Saylor, though, correct?
I don't know. I'm not really big on this whole law stuff. I'm just here saying what I know.
All right, thank you. No further questions, Your Honor.
Mr. Jane, any redirect?
Yes, Your Honor, brief redirect. Now, Mr. Tarr, Mr. Schultz mentioned a bonus that you thought you deserved on cross-examination. Could you explain to the jury why you believed you deserved this bonus?
Yeah, sure. Bryson had gotten into a bit of trouble with the DA. So, me being
Objection, Your Honor. What Mr. Tarr is about to go into is actually character evidence under Rule 404.
What's your response, Mr. Jane?
Your Honor, Mr. Schultz opened the door on cross-examination by asking Mr. Tarr about this bonus he thought he deserved. It's only fair for the jury to understand the context of this bonus, which is what Mr.
Your Honor, if I may, I actually refrain from going into this, why the bonus was reduced due to the fact that it is character evidence, and it's unfair prejudice, and it's unfair for the jury to hear it here today.
Any objection?
Sorry, was that a sustaining or a overrule?
Sustain.
Yes, Your Honor. No further questions, Mr. Tarr.
All right. Any brief recross?
None needed, Your Honor.
All right. All right. Any further proof from the defense?
No, Your Honor. At this time, the defense rests.
Thank you. All right, it's time for closing argument. Mr. Trenton White, I believe, is arguing for the plaintiff.
Yes, Your Honor. And if I may, reserve up to a minute of my time
Yes, for rebuttal, that'll be fine.
for rebuttal.
That'll be fine. Proceed when you're ready, Mr. White.
Anything right now.
It's okay, you're a little frozen up, but once you get unfrozen, just take the wheel.
All right.
And in case you didn't hear me, yes, you can reserve that 1 minute for rebuttal, but go ahead when you're ready.
Oh, thank you, Your Honor.
Mhm.
May it please the court, counsel, and members of the jury. My name is Trent White, and I represent the plaintiff, Bryson Saylor. Ladies and gentlemen, before you watch today's trial, we asked you to keep in mind the burden of proof. Today, we had to prove that the defendant intentionally, unlawfully, and harmfully caused offensive physical contact with Bryson Saylor. And we had to prove this by a preponderance of the evidence, meaning that the evidence in this case must lead you to conclude that our charge is more likely true than not. Now, not only have we proven that these allegations are more likely true than not, we went even further. Today, we don't have to prove damages. We have to prove intent. And that's exactly what we did. We displayed Bryson's innocence to you and uncovered the defendant's insidious intentions and irrational actions. And as you go back to deliberate among yourselves in a moment, I asked you to keep in mind the burden of proof. We are here today as a result of the defendant's intentional, unlawful, and harmful choices on September 5th, 2019. The choices the defendant made led him to court here today. To put it simple, the defendant chose to take the toolbox over to the area where the food was being prepared. The defendant chose to take Mr. Saylor's order, and the defendant chose to place a 1-inch galvanized decking screw in Bryson's sandwich. That action was irrational and creates concern for insidious intent. The roaring chaos of the protesters, along with the growing lunch crowds in the defendant's restaurant, was exactly the opportunity he needed to place the screw in Bryson's sandwich. Just prior to checking and preparing Bryson's sandwich, the defendant had direct contact with the same type of screw Bryson ingested. The defendant had the opportunity, and he took it, sending Bryson Saylor to the emergency room the very same day. Now, you heard Dr. Cares describe the excruciating procedure Bryson had to endure as she removed the screw from his stomach. The procedure, along with the undetected harm the screw caused, led to Bryson having an insurmountable amount of pain for weeks. Ladies and gentlemen, that's harm. And when you heard Bryson testify today, you heard him lay out what happened on September 5th. Bryson wanted to try the new restaurant and see if there was anything he could do to improve his own business. Bryson described the chaotic scene that was the defendant's restaurant. He highlighted the large crowds, protesters dressed as chickens, an environment of absolute chaos, but a perfect environment for the defendant to go under the radar. Ladies and gentlemen, today the plaintiff is here to prove that the defendant has committed battery on Mr. Saylor on the civil scale. And when you get to the bottom of it, the facts are simple. The defendant had the screw. The defendant took Bryson's order. The defendant checked Bryson's order. And the defendant took Bryson's order to the plaintiff. And moments later, Bryson Saylor ingested a 1-inch galvanized decking screw. Is this a coincidence or insidious intent? Today, the defense has made this burden seem as if it is an impossible goal for the plaintiff to reach. However, through a series of circumstantial and direct evidence, we have greatly surpassed this level of proof we must present today. Ladies and gentlemen, the defense has been shown to be defenseless. We urge you to protect Bryson's career. We urge you to protect Bryson's reputation. And with the facts in this case piled on our side, the plaintiff knows you'll make the right decision. Please rule in favor of the plaintiff and against the defense's insidious intentions. Thank you.
Thank you, Mr. White. Mr. Roy, on behalf of the defense.
May it please the court, opposing counsel, members of the jury. As I was listening to Mr. White's argument just now, one question kept repeating itself over and over in my head. Why? Why in the world would Drew Jennings sabotage his own new restaurant? And why would he throw away everything he has and intentionally choose the negative publicity and loss of sales that would inevitably result from attacking his own customer? Members of the jury, when you sat down and logged onto your computer to join this proceeding, you didn't leave your common sense in the other room, brought right here to this trial. When you apply common sense to the facts you've heard today, the logical explanation is not that Drew Jennings sabotaged his own new restaurant. No. The logical explanation for how a screw ended up on that chicken sandwich is that a radical protester saw an opportunity to kill two birds with one screw, and he took it. But before I talk about the evidence that points at a protester in a full chicken costume as the real culprit, let's talk about the burden of proof. Because it was not Mr. Jennings' burden to prove anything today. It was the plaintiff and the plaintiff alone, who was to prove by preponderance of the evidence that Drew Jennings caused harmful and offensive physical contact to Bryson Saylor by intentionally placing a screw in his chicken sandwich. Now, even if you consider all the possibilities for how a screw could have ended up on that sandwich, and you use your common sense, the plaintiff's story of self-sabotage, the story that it is their burden to prove today, is the one possibility that completely defies all logic. Because evidence of an intentional battery by Drew Jennings simply does not exist. None of the plaintiff's witnesses offered any actual evidence about who put the screw on the chicken sandwich. The best they could offer was that Drew Jennings and Mr. Saylor were competitors, that Mr. Jennings took and served Mr. Saylor's food, that Mr. Jennings had a toolbox somewhere inside the restaurant because he happened to be hanging up signs when the plaintiff walked in. That's all true, members of the jury. It just doesn't prove anything. Neither Bryson Saylor nor Austin Biltmore saw who put the screw on the chicken sandwich. And the toolbox? Mr. Jennings told you himself that he never even put the toolbox on the counter. Let's not forget that on cross-examination, Bryson Saylor admitted that my client was nothing but friendly on September 5th. No anger, no threats, no menacing behavior, just friendly. Members of the jury, friendliness doesn't prove intentional battery. It proves great customer service. And that great customer service was probably why Mr. Jennings was winning in the free market to begin with. You heard how his business was booming. It was a plaintiff's business that was down 25%. Mr. Jennings stood to gain nothing and lose everything if he attacked Mr. Saylor. And plaintiff, on the other hand, filed this lawsuit after learning that he was losing business to Mr. Jennings. That just leaves one logical explanation. Who stood to gain by harming both Mr. Saylor and my client's business? Who had both the motive and the opportunity to kill two birds with one screw? The chicken protesters. The same group of protesters that had previously harassed Mr. Saylor to the point where their leader was arrested was also present at Eat More Chicken on September 5th to disrupt my client's business. And what better way to disrupt his business than by making it appear that he had served food containing a foreign object to a customer who it just so happens the protesters had harassed and targeted for years. Let's not forget, one of those protesters testified today. And she admitted to being angry at the plaintiff, admitted to trying to bring down my client's business, and admitted to bringing 1-inch galvanized screws on September 5th to Eat More Chicken. The same type of screws that was removed from Bryson Saylor's stomach. So it comes down to this. Did the plaintiff prove that it is more likely true than not that Drew Jennings sabotaged his own new business to harm a customer he had never even met before? Or is it more reasonable that a group of protesters with a history of harassment seized upon an opportunity to kill two birds with one screw? When you go to deliberate today, all you need to know to answer those questions is your common sense. Return a verdict in favor of Drew Jennings. Thank you.
Thank you. And Mr. White? Rebuttal?
Yes, Your Honor. May I ask how much time I have left?
You have 1 minute left. 1 minute remaining.
Thank you. Ladies and gentlemen, you just heard opposing counsel ask you to have common sense when you make your decision in just a moment. And I would have to agree with opposing counsel. You know, this case that you've heard today really just comes down to one person, Drew Jennings. Drew Jennings had nothing to lose, but Drew Jennings had everything to gain. And when we recall the events of September 5th, Drew Jennings fixing a picture on the wall, Drew Jennings notified of Bryson's presence immediately. Drew became rushed and didn't even have time to put a toolbox away. By the way, a toolbox that was that had the exact same type of screw, that Bryson ingested moments later. Once again, Drew Jennings had nothing to lose, but everything to gain. Please rule in favor of the plaintiff and against the defense's insidious intentions.
Thank you. And give everyone an opportunity just to get their scores in, but that concludes this matter. So, but I do want to say that, I was very impressed with both teams today. If you want to turn on your cameras, you can, so that we can see who you are. That helps the scorers and the jurors when they give you your scores to remember your names and what role you played and that sort of thing. But I was very impressed by the number and the quality of the objections that were made in this round by both sides. Very impressive. I tried this at the Grand Division before we came to the state this weekend, and I had not seen that. You kind of knew the case, and you knew there wasn't a whole lot you could object to because a lot of the things are stipulated as authentic and that sort of thing. So it makes it difficult. But you guys, all the way around, both teams had a number of good quality objections that were made. I saw a couple of times when objections could have been made and they were not. But I also saw both of you being very responsive to the turn of events as the trial went on. You know, there were facts that came out that you jumped on the opportunity to ask those questions. And then you tended to ignore the facts that didn't come out, which is exactly how you're going to act in a trial. So I thought you did very well. And the jurors may have comments or that you'd like to give, but I've probably told you guys this before if I had you or judged you ever before. So I apologize if you've heard it, but I was in high school mock trial competition in the 90s. So I was in your shoes long ago. Now, we didn't obviously have virtual competitions. We didn't even have the internet. I'm sure we did. Al Gore tells us we did, but we didn't use it. And so, at least not at my school. And I grew up in Memphis. So we ended up going to state, and it's just a very rewarding experience. And I know it's great to see all of you doing this. Do a lot of you want to go into law when you grow up? If you do, raise your hand. Yeah, I can already see a lot of you, like when you were doing your presentations and asking questions and making your statements. I mean, I was like, okay, that's a defense attorney for insurance agent. You know, that I mean, it's like, that's a criminal defense attorney. It's like, I could see a lot of you doing that in the future. You know, whatever you want to do in life is going to be great. But law is certainly a good, challenging and rewarding field. Do the jurors have anything they want to comment on or add to or say? Or
I'll just say everyone did an exceptional job. I think that the level of preparedness that you each exhibited was exemplary, and it was really a joy to participate and to see you present this case in this way.
You could definitely see the level of thought and preparation that each of you had put into your roles, which is really exciting to see. And also you could really see a sense of listening within each of you, which you don't typically see in mock trial, and you definitely don't typically see on Zoom meetings. So I was just thoroughly impressed with the way that every single one of you took the situation that we have right now, and you really ran with it. And that was really, really impressive to see.
Ms. Higby?
I didn't do mock trial in high school because it was on hiatus, but I wouldn't have done it in high school because I was too scared. I didn't do it in college because I was too scared. I didn't do it in law school because I was too scared. Should I have overcome my fear before passing the bar and all that? Probably, but watching you all reminds me why I was too scared, because you kids are already ahead of me in a lot of ways by having poise in the courtroom, not letting adverse objection rulings get under your skin. You just keep going. Maintaining a theme is good, like the two birds, one stone. So I can definitely see how you guys are a part of the state championship. So good luck for I don't know if you have to do it again immediately tomorrow morning, but whenever you do, good luck for that next round.
And Mr. Wantland?
You all did an excellent job. I really enjoyed to see the witnesses develop their own little characters and expand upon that, and the costumes. Mr. Roy, you did a great job on all of your presentations and arguments. I even liked when the lights went out and you weren't flustered by that. I think that was you. So that was good, and it was refreshing to see that it was actually like a court argument. It wasn't so much staged. It was very involved. He would play off the witnesses' responses and then play off other counsel's objections. So it was nice. It was very much like a courtroom proceeding.
Yep. All right. Well, good job to you guys. I've stopped giving verdicts because the rules say I can't give verdicts, so I won't do that. Anybody have anything else? Does the bailiff need us to do anything else?
No, this is Nathan, volunteer with the mock trial competition. Really appreciate. Great job to everyone. And just a reminder to the judge and jurors, please hit the submit button for your scorecards. But thank you all and appreciate it. Have a good night.
Thank you. Good night.
Thank you all so much for your time, by the way.
Thank you so much.
Thank you.
Appreciate it.
Thank you.
Thank you.